everyone and greetings of the day. I'm Komal, Mathur and I'm a legal intern at LEXIS and Company. So I hope you remember whatever we discussed in our last part. So this is the second part of corporate insolvency resolution process. In last part we studied about what is CIRP and who all can initiate this kind of process. Also we read about what is insolvency and in which code it is given. So now let us discuss each process. I told you that there are three kind of initiation, like three people can initiate this kind of process against the debtor. Now what are the process? So first is initiation by financial creditor. As per section 5 subsection 7 of the code, financial creditor means any person to whom the financial debt is owed and includes a person to whom such debt has been legally assigned or transferred. In simpler terms, financial creditor refers to those persons from whom money was borrowed and by the corporate debtor as a loan or against interest under any credit facilities, for example banks, financial institutions, NBFCs, etc. Now what is the process? A financial creditor, either by itself or jointly with other financial creditors or any other person on behalf of the financial creditor, may file an application for initiating corporate insolvency resolution process against a corporate debtor before the adjudicating authority, that is NCLT, when a default has occurred. Application for initiating CIRP shall include record of the default recorded with the information utility or such other record or evidence of default, name of the resolution professional proposed to act as an interim resolution professional, and any other information as may be specified by the board. Now, the adjudicating authority, that is the NCLT, shall within 14 days either accept or reject the application filed by the financial creditors. On acceptance of the application, the insolvency proceedings will commence from the date of such acceptance, and the order shall be sent within 7 days to both financial creditors and corporate debtors, along with the appointment of a proposed resolution professional. Now, on rejection of application, a notice to the applicant to rectify the defect in his application within 7 days of the receipt of such notice shall be provided. Now, the second kind of initiation I told you about in my previous video was by the operational creditors. As per section 5 subclause 20 of the code, operational creditor means a person to whom operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. These creditors are those who are in employment with the company or are owed some debt or are owing some debt in respect to the goods and services provided by them to the corporate debtor. For example, employees, suppliers, etc. Now, what is the process here? On default being occurred, the operational creditor shall send a demand notice to the corporate debtor for repayment of the money owed. The corporate debtor shall within 10 days of demand notice either give a proof of payment made by it to the creditor or give the existence of dispute against such sum owed in respect of financial creditor. Now, in the case operational creditor after 10 days of demand notice does not receive any payment or notice of dispute from the corporate debtor, shall file an application for adjudicating authority, that is NCLT, for initiating a corporate insolvency resolution process. The fourth step, application for initiating CIRP, shall include a copy of the invoice demanding payment or demand notice delivered by the operational creditor for the corporate debtor, an affidavit to the effect that there is no notice given by the corporate debtor relating to a dispute of unpaid operational debt, a copy of certificate from the financial institutions maintaining the accounts of operational creditor confirming that there is no payment of unpaid operational debt. Now, also a copy of any record with information utility confirming that there is no payment of unpaid operational debt of corporate debtor if available, or any other proofs as may be prescribed. And now here fifth point will be the adjudicating authority, that is NCLT, shall within 14 days either accept or reject the application filed by the operational creditors. On rejection of application, a notice to the applicant to rectify the defect in his application within 7 days of receipt of such notice shall be provided. Now, the third type of CIRP can be initiated by corporate applicant. As per section 5 clause 5 of the code, The following person can be corporate applicant, that is a corporate debtor or a member or partner of the corporate debtor who is authorized to make an application, an individual who is in charge of managing the operations and resources of the corporate debtor, a person who has control and supervision over the financial affairs of the corporate debtor. Now, what is the process here? On the occurrence of default, a corporate applicant may file an application for initiating the corporate insolvency resolution process with the adjudicating authority. Now, the application for initiating CIRP shall include the information relating to its book of accounts and such other documents for such period as may be specified, and the information relating to the resolution professional proposed to be appointed as interim resolution professional. Third, the special resolution passed by shareholders of the corporate debtor or resolution passed by shareholders by at least 3/4 of the total number of partners of a corporate debtor, as the case may be, approving the filing of the application. Now, third step will be the adjudicating authority, that is the NCLT, shall within 14 days either accept or reject the file filed by the corporate applicant. On rejection of application, a notice to the applicant to rectify the defect in his application within 7 days of the receipt of such notice shall be provided. Now, the corporate insolvency resolution process shall commence from the date of admission of application by the adjudicating authority, that is NCLT. So, these are the three kinds of process which can be initiated in case of CIR. That is the process named as corporate insolvency resolution process. So, that's it for today. Thank you everyone. Have a nice day.